This is the second time you are making me do this. I am going to ask you to leave the courtroom.
You've been asked to leave. Let's go. Grab the phone.
I will leave with my child.
No, grab
my
your phone, or we will take you and the chair out of this courtroom.
What is it that you want to do with your future?
I was, there's actually multiple things I was looking into.
Number one.
I really love working with animals.
All right.
On the record?
All right, this is case number D-12. The case is filed in the matter of petition by ma'am, would you go ahead? Well, we have an attorney. Mr. Jones, would you go ahead and state your appearance, please?
Yes, Your Honor. John Jones, bar number 6699, appearing on behalf of the plaintiff.
Good morning. Ma'am, would you go ahead and state your appearance?
My name is I am the objector to this petition. And I am also here because those rights came through me for the last 12 years and this motion was filed before the evidentiary hearing. I am here also representing him as well.
Well, you can't represent him because you're
His rights come through me, Your Honor, yes, they do.
Here we go.
We are here for both parties,
Okay,
absolutely.
She's not a lawyer.
No, stop. Okay. Let the record reflect that we were set for 9 o'clock this morning. I called 2 other cases because there's been a common dilatory appearance, something that the court has seen that has become common. So I called this case last. We are now 10:05. Let the record reflect that Mr. has not appeared either in person nor by audiovisual means. So I appreciate that. Most importantly, why don't you go ahead and tell me your name? I'm sorry, could you speak up?
Yes, I apologize.
Good morning. You're the child that's subject to this action, is that correct?
Yes.
I didn't confirm your date of birth before I came in, but I believe you've now made 18, right?
Yes, sir.
Congratulations.
Thank
Did you
you.
graduate from high school?
Yes, I did.
Good. When did you graduate?
I actually graduated, I believe it was Saturday. Yeah,
Saturday
Friday.
that just
Friday.
passed?
Yeah, Friday.
Congratulations. What high school did you graduate?
I graduated from Palo Verde.
Good. All right, we're here today. Let the record also reflect that we had a guardian ad litem, and the guardian ad litem is not appearing. I assume that has to do with your having attained the age of majority. So congratulations. We're here today for a motion seeking an order to show cause as to why and should not be held in contempt of court. You guys go ahead and sit down. Okay, Mr. Jones, this is your motion, and I've reviewed everything. I'm going back to the orders. Ma'am,
Your
Like the
Honor,
chair.
may I
would
request
you
the court?
please sit on your
The minor
side?
child is not a
Would
plaintiff
you
here.
please sit on your side, please?
Your Honor, could
Thank
you
you.
please
Thank you.
allow
I'm
who
gonna
is
ask
my
you,
child to
I'm gonna-
sit on the same
I'm
side?
gonna-
She's not part of the petition.
you see what we go through, Joan?
She has a
Please.
petition.
Would you please sit?
Is not her child.
Doesn't matter. Have a seat.
Okay, but Mr. Jones, like I said, I've read the motion, I've gone back to the applicable orders, and I don't mean to steal your thunder in presentation of your argument, but what I had a question, okay? And the real question that I had, I understand the seeking contempt on behalf of Ms. and Mr. I understand the second request, contempt on the part of. I understand the third request with regards to fees. What I was wondering is, if there is a finding of contempt made, what sanction are you seeking as a result of the contempt? Because I don't really see that in a motion.
Well, I mean, obviously the court has discretion in that regard, but at the end of the day, the typical sanction is $500 per contempt. You have the non-filing of the FTF, even though it was specifically ordered, so that's $500 against Ms. And then I believe the affidavit spells out 5 specific instances, even though we know there's dozens of specific instances, the ones that can actually be proven are spelled out, which would be an additional 4 contempt citations and sanctions. So it would be probably $2,500. Well, it would be $500 for not filing the FTF. You got testimony at the time of the hearing regarding child support, regarding, and so that order resolves sort of the need for his FTF other than the blatant violation of the order.
Yeah.
So it really is just a matter of saying, well, and again, as you know, I was intending to have that motion filed in time for it to be heard at our last hearing, but certain cases involving multiple homicides sort of derailed that train to its original intended course. So this motion was still pending when you adjudicated the more substantive matters. So there is no opposition, and I understand that typically a motion for order to show cause would require an evidentiary hearing when you don't file an opposition, mostly because I think Ms. made it clear she doesn't think you have any authority over her or her behavior at all. I think you could just grant the sanction. I'm sure it'll be the subject of the 10th or 11th appeal in this case, because they didn't file an opposition, or in any way show cause why the sanction would not be issued.
Very good, Joe. The reason why I asked about jail time, you are not seeking an imposition of jail time, because I look at, because of the status of the case at this time, with the minor child having attained the age of 18, a civil contempt proceeding is a proceeding whereby we attempt compliance, to pursue compliance with an order, okay? With regards to the compliance with the court's order, because the minor child has attained the age of majority, I think if you were to pursue jail time, we would actually be dealing with a criminal contempt proceeding, which calls into order a different process that I believe I have to follow. That's why I asked the question. So if I understand the answer to the question, you are seeking monetary sanctions as a result of the contempt that is alleged. Is that correct?
Correct.
Okay. All right. Good deal. Ms. Well, first off, let's start with Mr. Mr. For the record, it is now 10:12. He has still not appeared before the court.
His rights come through me, Your Honor. I am appearing for both of us.
Okay, ma'am. I hate.
We
ma'am,
are objectors.
You and I need to get on the same page.
You're right, we do,
I
Your
am
Honor.
trying-
You entered a ruling on March 8th that's told that he needed to litigate his paternity complaint for his paternity complaint, number one. Number two, for 12 solid years, you ignored the fact that he was his father. For 12 solid years, you denied him physical custody. You denied him legal custody with the court's mythical statute that his rights come directly through me, his biological mother. That is your game. Not even Judge Harder entertained any of this stuff. Judge Harder denied John Jones' motions for child support. Why? Because you were ordered to conduct an evidentiary hearing, Your Honor. You were ordered by the Supreme Court.
Now I'm going to.
Was not in the evidentiary hearing, and she is appearing today for the first time. My objection was placed on the record, Your Honor.
Sit down.
I did oppose his motion.
All right.
I opposed his
I don't
motion.
want to stay
I
here.
I don't appreciate you putting falsehoods on the record that I did not oppose.
Let's talk
Mr.
about
Jones'
falsehoods,
motion.
because it's important for your
That's
daughter
right.
to hear this.
That's right, exactly.
You
My
were-
daughter, who you've ignored for 12 solid years.
Ma'am.
This is her first time in court, and she's already attained the age of 18. As you
All right,
ignored
Johnson,
her
I can't take it
affidavit.
anymore. We got. This is the
I-
second time you are making me do this.
I
I'm
want
going to
to
ask you to leave the courtroom.
object to Mr.
Please
Jones' motion.
leave the courtroom.
No,
Okay,
absolutely
the
not.
marshal's going to take you out of the
no.
courtroom.
Come on.
I have a right. You cannot
Come on,
deny my
let's go.
due process.
No.
You don't get to deny my due process. I have a right to be here. I am his mother. The minor child is here. You, as a judge, are in non-compliance with the law.
Come on.
You should be
Hey.
held in contempt.
Let's go. Come on.
No, I am not
You gonna
leaving.
physically make me put handcuffs on you and take you out of here?
Mr. Johnson.
No.
Stop. Sir, ma'am.
You gonna make me put handcuffs on you and take you out of here? Mary,
will do so
get
of your
up,
own free will.
get up and leave the courtroom. The judge has asked you to leave.
I have a right to be
No,
here.
now you're gonna be held in contempt.
I am not
Listen,
exempt. I am a
listen.
Ma'am, you
litigant.
need
All
to
right.
leave the courtroom.
Come on.
Come
I
on.
am a litigant
Come
in
on.
this case.
Come on.
You've been asked to leave. Let's go. Grab the phone.
I will leave with my child.
No, grab
My
your phone, or we will take you and the chair out of this courtroom.
I would like my daughter to come with me.
Let's go. Let's go.
I have a right to be
Let's
here.
go.
I'm giving
You
Come
you,
on.
cannot, you,
Come on.
I would,
I've
Come on.
given you the right, man.
you
Come
have
on,
not
let's go.
given me the right.
Let's go.
Let's go, ma'am.
Let's go.
Okay.
Come on, outside.
Now, with that being said,
Take your hands off.
Well, get out of the courtroom.
I don't need to be
Because-
pushed.
because you just heard a statement made regarding me having done something for 12 years. Just so you know, I have been on the bench now approximately 15 months. So I think it goes without saying that I cannot be blamed for having done something for 12 years. Can we agree on that? Okay? And I don't think that's unfair. What you have witnessed here today has been a somewhat common occurrence, although typically not to this extent, of what has gone on for a very extended period of time in relation to you. You're now 18 years old. I tell parents in court all the time, there comes a point in time where if you really love something, you let it go. And if you have done the right thing by that something always comes back. I believe life is circular. Do you understand that?
Yes.
You do the right thing by a kid, the kid always comes back. Contrast that by doing the wrong thing by a kid, and the kid quite often does not come back. You're now 18. You're going to make decisions for yourself. You are now, under the laws of the state of Nevada, you are an adult. You are entitled to listen to things, listen to people. You are entitled to now make decisions as to who's being truthful, who's being untruthful, who really has your interest at heart, and who really doesn't have your interest at heart. Do you understand that?
Yes.
That's going to be your opportunity when you walk out. You're now a high school graduate. I don't know what your future holds for you. I don't know whether college is in your future. I don't know whether trade school is in your future. I don't know what work is in your future. I don't know what relationships are in your future. I don't know what marriage is in your future. I don't know whether children are in your future. The one thing I will say with regards to children being in your future, unfortunately, you have been a part of this system for a period of time that is not fair to any child, in one judge's humble opinion, okay? If you learn anything from what has gone on today and in the last 12 years of your life, trust when Judge Gaudet tells you it is not best for children to be involved in this system for 12 years. Okay? It is not good for any child to be involved in this system for 12 years. Unfortunately, that has been the case with regards to you. Now, what I have to do today, just so you understand, we are not here today to argue who's right and who's wrong, things like we are here today because I, as a judge in first taking the bench in 2023, who truly believed I was doing the right thing. I had a situation where I had a mom who was having no contact with a child, and that had gone on for an extended period of time. What I did was I entered an order permitting that mom contact with the child by a certain means because I needed to make sure in my mind I was protecting the child. That means was by phone and what do you guys call it? App, whatever you call it.
FaceTime.
FaceTime.
Yes.
Okay. And now I'm being told that my order was violated. There was another situation that caused me concern, and that had to do with 2 cell phones. There's no reason to have 2 cell phones, and that creates problem after problem after problem in these cases down here. I see that all the time. So the order was 1 cell phone, okay? But apparently there was a lack of respect for the orders that I entered, okay? Which has brought us here today. Now, there was another order that I entered, and it was a really simple order. These cases down here require financial disclosures. There's a reason we require financial disclosures, and that reason is to make sure everybody's being fair with one another, right? And in this particular case, I had 2 people just flip their nose at my order. To this day, they still haven't complied with my order, okay? So what the court is going to do, typically, I would set this for an evidentiary hearing to take evidence. I don't think I need to do that with regards to the financial disclosures, because I can look at the file. It's all 900 or 1,000 pleadings, whatever it is, are directly in front of me, and I can see that my order has not been complied with regards to the financial disclosures, okay? So I don't think I have to go far. Mr. Jones, what we're gonna do is, with regards to Mr. the court is going to make specific findings that as of October 11, 2023, in relation to a hearing that was held on September 26, 2023, there was a specific order of the court contained at page 2 of the order that was filed October 10th of 2023. Paragraph 2, line 23, specifically states, Mr. shall prepare and file financial disclosure form, FDF, and attach pay stubs and or profit loss statements pursuant to the directive of the rule no later than October 3 of 2023. We've already had an evidentiary hearing. His not complying with my order required us to go through what I believe was an unnecessary burden, because at that point I had to solicit information on his earnings. He is obviously in contempt of court with regards to that order. There still has not been an FDF filed. The court is going to find him to be in contempt of court. He is going to receive a sanction, or he's going to be sanctioned with a financial in the financial sum of $500 for violating the content of the court's order. With regards to that same order, filed October 10, 2023, at page 2, beginning at line 19, the paragraph is numbered 1, shall prepare and file a financial disclosure form, FDF, and attach pay stubs and our profit and loss statements pursuant to the directive of the rule no later than October 3, 2023. Of course, we know, looking at the file, that hasn't been done either. That was discussed at the prior evidentiary hearing. The court is going to make a finding that Ms. is in contempt of court for not following the dictate of that order. She is going to be sanctioned $500 for failure to comply with the court's order. The second part of this has to do with an order that was filed by the court on April 19, 2023. It was from a hearing that was held on April 13th of 2023. The specific content at the order in question is contained at pages 4 to 5 of the order. Now this is how simple this was. What I took was compliance with the order, okay? Beginning at line 22. It is further ordered that shall have one cellular telephone, one and only one cellular telephone, which shall be provided by the telephone number for the cell phone is 725. Shall only utilize this cell phone. Or shall be provided with one cellular telephone contact per week on Saturday at 8 p.m. with one minute. The cellular telephone contact to be by way of FaceTime or other video capability. The FaceTime contact, cellular telephone contact will be supervised by who will have permission to record the contact. The contact will last no more than 30 minutes and will be permitted to record the contact. There will be no disparaging comments made to the child regarding any of his family, regarding his attorney, regarding anything to do with the court expects there to be peace and tranquility. Makes sense, huh? Peace and tranquility during these contacts, because that is going to serve his best interests. That was the order. Now I'm being told that there was at least, by my calculation, I saw 4. Counsel said 5. I could have miscounted them when I went through the content of the motion. I do feel compelled, Mr. Jones, if you desire us pursuing these sanctions, I feel compelled to issue a specific order to show cause,
Right.
requiring her to appear so that we can take testimony on the issue of whether or not that portion of my order was violated. When I read the contempt statutes, the local rules that apply to contempt, I believe that is
I
necessary
agree.
in this particular instance. So
I agree.
if you're desirous through pursuing contempt on those violations, I think the law requires me to issue the order to show cause. With that being said, are you desirous of doing that?
I agree with you, Your Honor, and I will obviously talk to my client about, and I understand, I understood that at least the things that were not direct contempt in front of the court would require an evidentiary proceeding. And I will discuss with her, whether, the additional $500 per violation sanction, is in her interest worth doing at this stage with the child, emancipated. And again, very few things I've been more proud in my life than this child graduating from high school because of my client.
Yeah. Well, with that being said, allow me to make a statement. You heard what I told you about letting things go and life being circular and they're coming back, okay? This poor child has now endured approximately 12 years of this, okay? I am going to issue the order to show cause. That doesn't mean we have to have yet another evidentiary hearing. Because just as I spoke to her as honestly as I could, I'm going to speak to you as honestly as I can, okay? There comes a point in time where if we let something go and we trust that we have done the right thing by that something, life is circular. That's something will come back. That something may have to go out there and personally experience right versus wrong to be able to make an independent evaluation as to what is actually right versus wrong before that something will come back, okay? But just as I said, we deal with this every day down here, okay? Teenage discretion, it goes on and on and on. And if you trust in yourself, if you have the self-esteem in yourself, if you have self-respect with yourself, if you know that you, as a parent, did the right thing by this, I'm going to call you a little girl, okay? Don't take that the wrong way, but I'm going to call you a little girl, okay? If you trust that you have done the right things for the last 12 years, okay, she will recognize that somewhere along the lines. And so all we want is harmony. A child, a young adult child,
Yes.
can never have too many people in her life that love her.
Correct.
Okay? Never. I will go to my grave not believing that. Okay? You can never have too many people on your side. Okay? The problem is she needs to now go out and determine what is the right thing to have at her side. Okay? She needs to set up boundaries. She needs to determine right versus wrong. Okay? I am not telling you this to preach to you. That's not what I'm trying to do. I'm trying to tell you this so that you can walk out of this courtroom and utilize those scales of justice. The cost of proceeding with yet another evidentiary hearing versus the gain to be had by conducting that evidentiary hearing. Does that make sense? If the cost outweighs the gain, what's the decision? Pretty obvious to me. If the gain outweighs the cost, pretty obvious decision. Any decision you make in life, you utilize those scales of justice. Listen to me. Any decision you make in life, you utilize those scales of justice. If the cost outweighs the benefit, you don't proceed. If the benefit outweighs the cost, you proceed. Pretty simple, right?
Yes.
Okay. But anyway.
Well, and Judge, your comments are ones that I share, and I have shared with my client. It's just, in a case like this, and again, I've been attacked by Ms. because I've continued to represent the plaintiff pro bono for more than a decade, which is, let's just say, doesn't exist. The reason I did is, it takes a lot to convince me, for a client to convince me that all they truly want is what's best for the child. And I never had a doubt for the last 12 years that the plaintiff was acting solely for the child and having nothing to do with herself. And that's why, my law firm has probably incurred, hundreds of thousands, if not, when you have a case going on for more than a decade, generally the fees at my hourly rate would be in the $1 million range. I've stayed on this case for no other reason than to protect this child and to make sure that no harm came to her, because I knew that my client had been doing the right thing, and that's why I've stayed on this case. I will talk to her about whether we submit to you the actual order to show cause. Your ruling is clear. I can submit an order to show cause if she chooses for me to do so, at which point I'm sure you will sign it and set the hearing date. We'll make that decision, and you'll know the decision is made whether you receive an order to show cause to sign or not.
And that was gonna be my suggestion. Usually I would actually give you the order to show cause date right now. I'm not gonna do that. Today's Tuesday. I'll allow you guys, let's say by Friday, because you should be able to make this. Yes, ma'am, you wanted to say?
I try, can I have till next Friday, Your Honor?
Oh, yeah, absolutely. Ma'am, you wanted to say something. Go ahead.
And thank you. I sit here and quiet all the time for the last 12 years. It never had to get like this.
I agree.
You put down some orders. The previous judges have put down orders. We had a nice timeshare. It could have worked out lovely. You see the individual that I'm dealing with, and it's a shame. We don't need to go on any further. All I ever really wanted was fair child support, which this person is working 2 jobs and making more than $50,000. That's all I wanted to be equated, just to be fair.
I understand.
Because after
Which is why I wanted financial disclosure plans.
right, and I don't want an affidavit being
Well,
drafted.
I'm gonna discuss that in a second.
It's a shame.
Yeah, okay.
So
I have both.
I don't.
And look,
There's no.
No, I'm gonna discuss it with the child. I have both of them.
Because now is now going to be residing with, and I just don't like the games like, here, you need to sign this. It's not fair, and
Yeah.
and I would love if
Well, I was
That's-
planning on, you're kind of stealing my thunder here.
I
but-
don't want to steal your thunder, but
Okay, let's.
it is my
stop.
birthday, so
Happy birthday. I'm gonna say you caused, but you didn't cause. There was affidavit in support of denial of petition for failure to obtain consent required by a statute, and affidavit in support of objection to the request. That was filed on February 26, 2024. It didn't stop there. You in the office preparing my week's calendar yesterday. It was a holiday, but I came into the office to prepare my calendar. I didn't see anything filed by the other side. And then I got here this morning, there was something, I wasn't here until 5:45 yesterday, okay? But at 5:45 yesterday afternoon, on a holiday, on the eve before us coming into court, there is yet another, so a little differently. Stated February 26, 2024, affidavit of demand to void legal paternity proceedings, as well as the other issue, the order issued May 1 of 2024. I read these. Okay, I read them before. I read the February one before. I'm going to make a statement, and if I'm wrong, correct me right away. Okay, I open you to correct me. I would assume this was prepared for you by somebody else. Am I right? Yes, Your Honor.
Yes, Your
I
Honor.
expect you to treat me with that kind of
Yes,
respect.
yes, Your Honor.
I would assume that it was not Mr. that prepared this. Am I right?
Yes, Your Honor.
I would assume that it was Miss that prepared this. Am I right?
Yes, Your Honor.
Did you have any input into the preparation of these affidavits?
I truly think I only
I'm sorry, say again?
I truly think I only skimmed over it. I don't really know.
You see, that is how unfair this is to you. I hope you understand, I, as a district court judge, when I'm dealing with children in custody matters, I say this kind of tongue in cheek. My concern is not with Ms. My concern is not with Ms. My concern is not with Mr. What do you think my primary concern is? You. Okay, the child. That's how we have to deal with these things. That doesn't mean, and trust me, this is not some sort of anomaly. We see this all the time down here, although this has gotten beyond what we typically see down here, okay? But we see parents attempting to or manipulating other people in furtherance of their goals all the time, okay? Just like I just, she has to have self-respect. She has to have self-confidence. She has to, I know you're only 18 years old, but that same statement applies to you. Do you understand why? For the next, the average age for a lady in the United States right now, I think is 78 or 79. It's going up, or it's so you have another 50, 60 years left on this earth, okay? You have to have the self-confidence. You have to have the self-respect, dignity, blah, 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 to be able to listen, make decisions, just like I told you earlier, right versus wrong, and stand up for yourself in imposing what you believe is right versus wrong. Do you understand that? With that being said, the court gives very little weight. No, put your hand down for a second. You have been very, very quiet during these proceedings, and I really appreciate that, okay? The court gives little weight, if any, to the content of these affidavits. And I will not hold that against you. I mean, I'm not the brightest bulb in the Christmas tree, but I'm reasonably intelligent. And when I read these, I could pretty much tell this wasn't your hand, your mouth, or your fingers doing the typing. I'm not stupid, okay? I just hope, I wish you the absolute best in your future. You are a party to this action. You are now above the age of majority. You have the right to review the pleadings in this action. By no means am I trying to upset you at all, but I think knowledge is the most important thing to make us productive in the future, okay? And, you know, I don't know what's being told to you by one side. I don't know what's being told to you by another side, or in this case, another side, okay? But I know what's on file in this case. And it's sad. But as of today, you can make a conscious decision, or you will make conscious decisions on what's right versus what's wrong for, okay? And I really, really hope you make the right decision. Now, ma'am, you raised your hand, you wanted to say something, go ahead. I'm not a counselor.
No, it's okay, but like, it's just not fair to put in this position.
Okay, let's
Because here's a script.
let's suppose I 120% agree with you. As a judge, I deal with certain things. I call it ringing the bell. That bell has been rung. I can't unring the bell. Do you understand what I'm saying? It's like if we were trying a case and your attorney heard a question having to deal with a hearsay response, and he waits a split second too late and he makes the objection, but the response has already come out. As a judge, I can say, sustain. Ladies and gentlemen of the jury, you are to disregard the answer.
Yes.
But the reality of the situation is the bell has already been rung. Okay, just listen. The bell has been rung.
Yes.
Okay, so now she, as an individual, as an adult, needs to realize that the bell has been rung for whatever reason, and now she needs to, look, this situation ain't gonna fix itself in 2 weeks. This ain't gonna fix itself in 6 months. Okay, you never heard Judge Gaudet say that, okay? But this situation will fix itself because as she becomes older, matures, and gains knowledge, she is going to make an independent decision as to right versus wrong, okay? She's not an adult. That's her job. Not a job. That's her obligation to. I truly hope you live as emotionally healthy a life as you possibly can. Okay. And unfortunately, what has happened in the last 12 years has put a lot of burden upon you, okay? And that burden ain't gonna stop today, okay? It's not. But you have the right to dictate where your life goes, okay? Not her, not him, not me, you, okay? And you know, I just hope you make the right decisions. I really do. What is it that you want to do with your future?
I was, there's actually multiple things I was looking into.
Number one.
I really love working with animals, so I was thinking about becoming a vet tech, something along those lines.
Number two.
Something with cosmetology maybe, and then the third would be, I'm really into drawing, but sometimes I tend to lose like creativity and I need a break, so I think I would keep that as like a hobby.
Well, let me just tell you this, you just made 18 and at least you've thought about those things,
Yes.
okay? So I'm proud of you for doing that. I'll make another statement, the things that you think of as 18, at 18, doesn't necessarily mean those are the things you will be doing at 30, okay? So leave your options open. My advice to you would be leave your options open, have goals, come up with a plan to achieve your goals, and put the plan in process, okay? So, but once again, those are decisions that you have to make independently. Okay? In any event, all right, with that being said, I want to ask you, do you understand what I've done here today?
Yes.
With regards to the findings of contempt and you probably don't know what an order to show cause is. When there's an allegation that someone has not complied with an order of the court, we can consider that non-compliance by way of motion. And the motion is typically for an order to show cause, requiring the person who is alleged to have not complied with the order to appear and present evidence pertaining to compliance, lack of compliance, and why they didn't comply. Okay, now I know that's a bunch of words, but does that kind of make sense to you?
Yes, sir.
Okay, now with regards to the financial disclosure forms, I don't think I need to take evidence on that because that was my order and that was basically committed in my presence because I can see that the financial disclosure forms weren't filed. Do you understand that?
Yes.
Okay, all right, good deal. Anyway, all right. Mr. Jones, do you have any questions?
I know, I kind of predicted that this is how the court would handle these matters. I will discuss with my client whether we submit the order to show cause to you. But otherwise, your comments too were, in my opinion, more Solomon-like than Solomon could do himself. And also recognizes that, you know, clearly there's been one person here in this case who has fought for nothing other than what's best for them. And I appreciate that the court has recognized that. I just hope that while getting pressure from other sides, that she realizes that too. And like you said, things will come around, realizations will be made that, yeah, maybe this isn't what's best for me. And then changes and decisions will be made. And the one thing I know for sure is my client, who I've known for more than a decade now, is always going to be there for this kid. So that's all that the security blanket she has is that. But I'll prepare an order from today. I'll talk to my client about whether I submit an order to show cause by next Friday. And maybe we'll have another hearing, maybe we won't. And we'll go from there.
I'm going to make one other suggestion because you're a party to the action. You can go downstairs. I'm not your attorney. I'm making a suggestion. You go downstairs and actually file for e-service, okay? Where I assume you have an email address. Am I right or am I wrong?
You're correct.
Okay. You can go down there and you can give them your email address and actually where you get notification. For instance, if there's an order to show cause entered, when I sign it, it's filed. It'll be sent to your email address too. You're independent at that point. You're not relying upon. You're not relying upon this. You're not relying upon Mr. sorry, I pronounced the name, I mispronounce the name frequently, I apologize.
Sadly, Judge, I think she's already been given a lot of pleadings in this case, so.
I think it's, you know, I would never suggest this to a 12 or 13-year-old kid, okay? I probably wouldn't suggest it. There would be a small percentage of young adults that I would suggest this to. But I'm gonna be honest, I think when I opened this file 15 months ago, I'm thinking, my goodness, what is going on in this poor little girl's life? You know, and I know time is limited. I know reading takes a lot of time, and there are extensive pleadings in this case, okay? But you have the right to do it, and I don't think it would adversely affect you to know what is going on. I think it would probably make you a stronger person in the future. It would, in my humble opinion. Okay, but that's your choice, and you see how I'm deferring to you. It's time for you to make decisions on that, not somebody else. Okay, I would suggest in the future be careful when somebody gives you something to sign. Okay, there's a little thing out there called contract law and consumer debt and mortgages and vehicle loans. You know, be kind of careful what you sign and stuff. But I sound like your dad. No, I'm not your dad. I'm your judge. All right. With that being said, we're going to go ahead and conclude the hearing. We're going to go off record.
Thank you, Judge.
I thank everybody for appearing. The absolute best of luck in your future. I'm going to make a statement. I hope I never see you again in my life. Tongue in cheek. Okay.
And that's
no,
okay.
you don't have to respond. I wish you the absolute best of luck in the future. Mr. Jones, I would say I wish I never see you again, but that's impossible. I'm going to see you again somewhere.
I'm sure you will.
You guys have a great day. Thank you very much.
Thanks, Judge.
Yep.